Daily list for hearing. Item 8.
Lord, if I may just give a brief overview. It's actually a very short matter, and a review petition filed by the Employee State Insurance Corporation,
Which was allowed.
was allowed. So I'll just read that. That actually sets out whatever's the argument to be made by me. So can I just read that? And I believe it will make the matter extremely short. Has your lordship got the order in review?
Yes. Review order dated 8/8/2023.
Yes, no. Should I read it?
No, you tell us. Don't read the entire order.
All right. Actually, it's not a very long order, but I'll tell your lordship.
You read it.
No, I'll explain. I'm very happy to explain. My lord, let me try and
No, but
explain.
read from paragraph 3 onwards.
Yes,
It's very
Lord.
clearly written. Yes. It's a very
Yes.
short order. Please.
Before any dilation on the issues, it appears apposite to narrate the facts in brief which led to the institution of the present petition. The respondents preferred the original application inter alia that they were initially appointed in different capacities under the government of Assam. While they were working in the government of Assam, the ESIC took over the hospital at Tola, Guwahati, from the state government with its assets, liabilities. These private respondents, who were erstwhile employees of the hospital, were absorbed on permanent basis in different posts. Petition number 1, for example, is a pharmacist. I'll go on to the next line. Their permanent absorption in the ESIC model hospital in such manner was on the basis of terms and conditions. Now, the absorption was on 1/1/2006. That's one important date. As per the terms and conditions, they were offered benefits of ACP and MACP. Now, what has happened is that subsequently there was a circular, or prior to this, there was a circular of 9/8/99. I'll just come to that circular. And that circular was further clarified on 10/2/2000. That is with regard to the MACP and ACP. The only thing that circular says basically is this, and the clarification that if a person is absorbed on a higher pay scale, with regard to the petitioners, the issue is if they're absorbed on a higher pay scale, then they will not get the benefit of past service. Then their service will be counted from the date of absorption, which is 1/1/2006. Then I come to paragraph 4, if I may read. When the private respondents were continuing their services under the ESIC, after their permanent absorption, a communication dated 19/25/10/12 was exchanged between authorities in the ESIC on the subject of grant of ACP from date of taking over or the ESIC model hospital. A difference in pay scale in the post of pharmacist under the state government and under ESIC was noticed in that the pharmacists under the state were given a pay scale of 3,490 to 8,000, whereas same pharmacist, when he was absorbed in ESIC, was given a pay scale of 4,500 to 7,000. It was observed that in view of the clarifications provided by clarification number 6 and 29 of his memo dated 10/2/2000 DOPT, if any absorption was made with a higher scale then such appointment should be treated as direct recruitment, and such employees' past service shall not count for grant of benefits under the ACP scheme after absorption. In another internal communication dated 8/7/15, exchange between the authorities of ESIC, it was observed in cases where entry pay scale in a particular cadre in ESIC was higher than the pay scale drawn by the employee under the state government, then the employee had been granted the entry grade scale as per ESIC norms. Therefore, in such cases, service in the pay scale would commence from the date of absorption for grant of benefits under the ACP, MACP. The concerned authority was requested to identify cases for corrective action. That's when these employees, and I don't need to read the review necessarily, I can, but I just wanted to show that this is a short point. Will they be entitled to service from 1/16 when they came into ESIC? Because when they came,
That's
came.
that's all right. They were on the same or analogous post, but with a higher pay scale.
That's the short issue. And there was an earlier judgment of your lordships in Koshal Sharma, which seemed to have said that the DOPT clarification of 10th February is quashed. Now, one, it was per incurium, because in that case, it was a parity between CAT employees and High Court employees. I think grade 4 employees. And in that, there was no difference of scale or service. And that's why the past service would have been counted. Therefore, Kushal Sharma really is per incurium to the extent
Can
that
you
it
take
is
us to
talking
Koshal
of,
Sharma reasoning
yes,
of the High Court for quashing this memo of 2000, 10 to 2000. Please show us.
yes. So, my lord, that is Kushal Sharma, if your lordship will see. It is there in,
Page?
it's page 8 of the review.
No. Tell us from this petition, no?
Petition.
Review has been disposed of. You have read the order. We don't have the records here.
Oh, I see.
Show us,
Um,
show us the review. It has been disposed of. No, show us from here.
I'll
Kushal
just
must
see
have
if
been-
it's there. One. I'll just see. If it's there. So there is, I think,
The CAT order, the tribunal's order at page 87 only refers to
115.
the last paragraph of Kushal.
yes,
Kushal. It
yes.
says, as such, we are of the opinion that the service reckonable for the purpose of ACB will include the period during which the applicant was working with the state government. Accordingly, we set aside. What is the reasoning?
My lord, it's page 160 of in your in the law in the writ petition before your lordship. Last page.
Yes, that's good.
Yes. So may I just
Read paragraph 5.
read that? Actually, because Kushal was really not addressing that issue, but I'll
Yes,
read
please.
paragraph 5. The issue framed by the tribunal in OA was whether the service of the state government for the purpose of ACP will be counted only from the date of their absorption in the central government service. The claim of the two applicants to count their service in the Guwahati High Court was rejected by the employer on 30th October 7, whereby it was held that in case of employees of state government service for purposes of ACP benefit will be counted only from the date of their absorption in the CAT. Now, my lord, come to
7.
para or 7. In M. Ramchandran versus Govind Balla, reported in 1999, Supreme Court observed that length of service in the same class category or grade is a recognized mode of determining seniority. Accordingly, it was held that when service is rendered in the parent department in an equivalent post, that period of service in the parent department should be taken into account for the purpose of determining seniority, and any other interpretation would be against the rules of settled rules of service jurisprudence. The ratio of the judgment was considered by the tribunal. It was decided that past service in the same rank should be reckoned for the two applicants to grant them the second financial upgradation in accordance with the OM dated 9/8/99. At that stage, it is now, my lord, in Koshal, the difference was, and this is what I'm going to read in para 9, that they were actually same posts and there was no pay parity difference. At that stage, it will be appropriate to take note that the respondent Koshal Sharma joined service in regular posts of LDA in the establishment of Guwahati High Court in 76. Respondent Imran joined in 77. Both of them were brought on deputation in CAT. They were eventually absorbed in CAT. If we take into account the earlier service in the High Court, 12-year period for the respondent, so and so, they will be entitled to ACP.
Say that though the division bench said that it is post, but actually they meant that it was not applicable to the case
Actually,
of Koshal.
that's all. It's
If you don't challenge it, you have not challenged it. So that exists. Mr. Datta will tell us what.
yes. So now, if we come to just a series of judgments by various courts, and I've given that compilation to your lordship. Mostly Delhi High Court, but there are other courts also.
Why this fascination with Delhi High Court?
Because perhaps your lordship was there for a while, so it is opposite. So can I just refer to two judgments? And so Ramchandran, for example,
Yes.
Ramchandran, for example, which is quoted in this case, is a case where all it's saying is if there's pay parity, if there is same.
That's right. Length of
that's
service,
all.
doing the same
So
work, all right.
Ramchandran doesn't really help. If I can show P.S. Rajput, although I gave a compilation, but perhaps it may not be. Huh?
You've
No,
given a
it's
compilation.
here also. I gave it this
You've
one.
given a compilation.
But just give P.S. Rajput. Because there, Justice Sistani's bench, sitting with Jyoti Singh, Justice Jyoti Singh, exactly these two gives quote for. Where is it? Yes, this one, Yes,
These are just facts, no?
you have it. You have. Okay. So, my lord, if I may take your lordships to P.S. Rajput for as the first judgment, because that really is dealing with these two clarifications in the OM. And I'll show that OM to your lordship actually also. But if your lordship sees P.S. Rajput, 2019 SCC Online Delhi 7081. My lord, para 16, if your lordship comes to. Should I read the fact
minute.
or?
So this relies where there's no reference. This is just the principle. There is no reference to that OA.
No, there is. I'll just, no, to the,
OA of 2000.
no, OM. My lord, there is para 16. PS Raj.
Yes,
you
yes,
have
it is
promised.
there.
I'll just
Yes,
show.
yes, it's there.
I'll just show. It is relevant to point out a DOPT OM
said.
dated 10th February 2000.
Same questions.
Yes.
6 and 29. You're right.
Yes. So para 16 and 18 actually deal with this. And they reproduce the fact that there are that the clarification number 6 and clarification number 29 in the OM are relevant.
All right.
Can I read from the bottom of para 16?
We have read paragraph 6.
Para 16.
These are the questions. Question number 6 and question number 29.
Yes. And it says, however, if the appointment is made to
Yes,
the
the only issue is that if he gets absorbed in a different organization, on a higher pay scale, same post, then that's direct recruitment. Therefore, it is not.
That's right. That's the only issue. And that's why we are saying that what.
The problem was Koshal. Koshal was on a different issue.
Yes, exactly.
OA
Kushal is not really dealing with this issue because in that it was there was parity. Now 16 and 18, and my lord, there are a series of judgments.
Where do we get the series?
We'll just, I thought I have filed it, but my colleague is just giving.
And give a
So,
copy to Mr. Datta as well.
yes, yes. Mr. Datta had the benefit of getting 2 copies even in the review. So Ajmer Singh, that's a single judge of Delhi High Court, Justice Kameshwar Rao. Then Bindu Singh, Justice Bhatt and Justice Deepa Sharma. That's a division bench. All of them are really talking about the DOPT circular, saying that is clarificatory of the 9th of.
Give those, Chair.
Yes.
And compile it and then give it.
I'll do.
Principle, we understand what you are conversing.
Ajmer Singh and Bindu Saigal.
Ajmer Singh, Bindu Saigal, and there's another nice one. MMJ Vij, also Justice Sistani and Justice I.S. Mehta. But the same issue.
This is what happens when you are fascinated with one high court. See, there are judgments of the Supreme Court which explain why it should not be done. Especially the judgment whereafter many other judgments of the high courts were reversed. I mean, with respect to just a minute, this ACP and MACP, there is a judgment by Justice Mithal, Pankaj Mithal, whereafter there were many review petitions in various courts. It explains what is the purpose and what was the rationale behind ACP, the service jurisprudence. In situ, this was a kind of in situ promotion, but not promotion, but financial upgradation. And therefore the concept. So you're only talking about such cases which deal with OM. OM, the CAT also, the tribunal has also dealt with it.
Actually, I'll tell you why I concentrated on the OM rather than the general thing. Because in this case, in Kushal, it was, so 9/8/99 was the circular or
That's
notification
right. So therefore,
which talks about MSCP and ACP.
you give us the judgments, but then let us come to the CAT, tribunal's judgment.
Yes.
So where has the tribunal dealt with this issue of Kushal? I think there's there.
Yes. My lord has it. It starts at page 96. starts at page 96 and talks about Koshal on page 106. Should I read major parts
No.
of it or?
No,
Yes.
just,
So,
no, just a minute. No, it has not been dealt with. It has only been stated. Thereafter, respondent authorities of the government of, that is government of India, have implemented the order passed by the tribunal as well as the Guwahati High Court. Now we have in hand the office memorandum dated so and so and query number 6 and 29.
Mhm.
Now the question comes apropos the aforesaid OM, which was set aside in case of Koshal, which was upheld by Guwahati High Court long back, and same attains finality, but the respondent authorities with the help of said OM again issued the impugned order dated Itna as well as consequential orders dated Itna, denying the benefits of counting past service. In view of that, it will include the period. We are of the opinion that service reckonable for the purpose of visible will include the period. It will just rely. So it has relied on that, no?
that's actually per incurium because firstly,
What do we do then?
justice in High Court ऋषिकेश रोही का जजमेंट दिखाना दोबारा.
All right. Yes, Mr. Tar.
My lord, the OM in the convenience compilation,
We don't have any compilation. You are under some.
it's page 220.
No,
It is there.
no, it is.
It is. I believe my colleague has passed it. She's unwell, my briefing from Guwahati. She was not well, but she's promised that she has put it on the court's record. So it's page
There is no problem. It can be done.
223.
No, we don't have that compilation. This is affidavit, no compilation. You have to.
No, below that is convenience compilation.
It's not here in the record. You have to file another 2 compilation for a spiral copy.
All right. All right. It's not there. It's not, they called it affidavit. Oh, they called it an affidavit. She said that according to the norms of this court, it has to be called an affidavit and not a convenience compilation. So my colleague
All right,
having,
so it is here. It's here.
my colleague having sent it. So what will be relevant is
No, we have
the,
seen that. We have seen that. So therefore, you say, now what do you have to say about the division bench judgment? One distinction that you made was that when he left High Court and joined CAT, there was no upgradation in the salary. Analogous post, he was on the same pay. And therefore, OM 2000 was not applicable to him.
that's right.
That's the only argument.
That's really the only argument. Also, while the CAT order in Koshal talks about it having been quashed, the High Court order, Justice, the division bench order, can you open Justice Hrishikesh Roy's order?
We just read it.
But my lord, that doesn't really talk about the OM in detail
No,
in
it's
that
like-
sense.
It has talked about Ramchandra Rao.
But Ramchandra Rao, I go by that principle because that is the principle which is the right one. That if it's same pay parity, same scale, then obviously past service has to be counted. If it isn't, so Ramchandra Rao really helps me. In fact, I'm also equally relying on Ramchandra Rao. I'm actually relying on that. But
All right, we have followed.
if I look
All right, I
at
was-
the High Court judgment, it hasn't really
We have
talked about,
That's right. So we were considering it only for the reason that since a bench of coeval strength has passed some order, but there is no discussion on that and facts are different.
that's,
Therefore, there is no requirement of it being sent to a larger bench because there is no issue involved here.
that's right.
The only thing which is there in our mind is that it was quashed. So that doesn't find favor with
That's-
us because the division bench would never have meant quashing it because that OA is being followed everywhere, in every high court, and that is one OA of the central government.
Yes.
Now, Guwahati High Court could not have quashed it just like that.
And in fact, in that para 12 by the Guwahati High
They
Court
followed, now let us,
order,
let
it
us-
says the OM dated 9/8/99 settles the issue. Therefore, to deny them would be unjust. So in fact, it's speaking in favor of the OM and the clarificatory OM, which is 10/2/2000.
all right, yes, Mr. Datta.
Well, this 10 to 2000, which is the hurdle of my VMO, that was set aside initially by the tribunal. It's the year 2011. That order of the tribunal was put to challenge in Kuchal, which was not interfered with by the Honorable Division. Kushal judgment your lordship has seen. In the judgment of Kushal Miller, there was no interference was to the order of the tribunal, which was passed in the year 2011. So 10 to 2000 circular was long time back set aside. They only reinvented the proposition. And Milord, on the merits, Milord. Contention on the merits is that, Milord, as I have understood, that we went on a higher base. That this aspect of the matter, Milord, barring the example of the first response, I'm sorry,
The pharmacist, the pharmacist.
pharmacist, Milord, there is no disclosure as to who went into.
You tell us,
Now,
you tell us
on,
that
on,
you
on
are.
that, Milord, we have filed an affidavit. And we have said that in the case of pharmacists, only the initial, stage of the entry, the pay at the entry level is only higher. If your lordship takes into account the scale, Milord, then the scale of the high court, I'm sorry, Milord, the scale of the
This was
pharmacist in the state government was high. I'll just show it to your lordship, Milord, from the affidavit that we have filed. Your lordship will kindly take the affidavit at page 99.
Who appears for the central government? Who appears for the central government? No, she appears for ESIC. Who appears for the central government? Call Mr. R.K.D. Chaudhary. He appears, no? He's one of the CGC. Who is the main central government count? Call him. You are his junior. You are also CGC. What is your name? Can you just send a word to Mr. R.K.D. Chaudhary? We'll be putting one question.
If your lordship will to demonstrate that point, if your lordship.
Where is your affidavit, Mr. Datta?
Well, your lordship to kindly come to page 146. The affidavit starts from page 95. Is their document, Milord, in which, Milord, this position has been acknowledged. Page 146. Okay, may I read it out to your lord? In reference to the subject cited above, I would like to inform you that so-and-so was serving as pharmacist since when? In the pay scale 34908100. On reputation to ESIC, his pay was in the scale of 4,500 to 7,000. It is the lowest pay scale.
No, therefore, it was, we read that the OM also says that you identify only such persons who were absorbed on a higher grade or higher pay scale.
Our case is that we never went on.
So
higher
therefore,
pay scale.
but then if you were, so on principle, you don't deny that if you have joined on a higher pay scale, the earlier service is not counted, correct?
That is the purport of the OM.
That is the purport of the OM, and you don't have anything to say to that.
Now, my only submission.
So therefore, it has to be clarified.
Yes.
And if it is found factually that you were, then only it shall be withdrawn. Correct? All right.
And all the petitioners.
So therefore, in principle, we need to allow this petition with a caveat that this recovery shall be done only after confirmation that these persons who got the benefit of,
My lord, there,
I mean, we are making it very clear to you.
yes, my lord, there, I'm just indicating, my lord, there may be another aspect also. All these persons have by now retired long time back. Now, whether,
Recovery could be done.
yes.
Address us on that. You don't fall in the category of Masi.
My lord, I
Grade
don't-
3, grade 4 and retired.
my
It
lord,
has to be adjusted from your pension, but nonetheless, you have a ground and those upgradation was done, those financial benefits you received when?
look, those were sometimes,
You give us the details, who has retired and when. You represent all respondents.
Yes.
Which judgment now? Rafiq Masi, there is another case which says that there cannot be any unjust enrichment.
but my lord, I would also.
Dekhen Rafiq Masi ka category.
But I would also try to emphasize on a point that these benefits were granted to us without any, I mean,
Misrepresentation.
misrepresentation from our side. So therefore, whether it would be just and proper to withdraw it from our pension now.
Rafiq Masi ke baad ye judgment Patel, which says that the principle is correct. The recovery from the employees belonging to class 3 and class 4, they are class 2.
There are
These
class 4 as well.
pharmacists, no,
There are class 4 as well, my lord. I'll just, in the cost title, my lord.
Recovery from the retired employees or the employees who are due to retire. So this is from the retired.
Except for the pharmacist, my lord.
no, there will be class 4 UDCs here, but there's lab technician, radiographer, all of
There are.
You fall
Yes.
in category 2 of Rafiq Masi.
Well-
Argue, Mr. Datta, if you don't argue, don't expect the court to
No, my
provide
lord,
you.
I'm just giving the facts, my lord.
Forget about facts.
Except for the pharmacist, my lord.
We have
Yeah,
followed that argument.
Others are in the category of orderly and assistant nurse.
So therefore, class 4.
Yes.
And even otherwise, recovery from retired employees,
Yes.
if there is no. But then there is another judgment
We'll
after
have
this.
to
What
do
is
the
it?
sub-
Patel.
Okay.
Yes, Ms. Luthra, what do you have to say to this?
So, my lord,
Except for one pharmacist, one cadre, all are class 3 and class 4.
I think,
And they have retired also.
my lord, he has to give those details.
No, he has those
Because
details, so it will be confirmed.
it
No
will be
condition.
confirmed. Your lordship may pass the orders and those,
Retired.
and those who are class 3, class 4, your lordship may say what
Who has
your,
filed this appeal here?
my lord, the writ was filed by us.
An appeal also filed by you.
The
No, so
review,
this is, sorry, not appeal. The writ has been filed by you. So
We-
who is the employer here?
ESI.
So who tells us that?
We can verify
when-
this.
when-
My lord, I'll verify this. Many of them are till lab technicians and assistants. They will not be class 3, class 4. The UDCs will be class 3, class 4.
Where is that?
My lord,
where is
this-
that exercise you've
This
done?
has been hanging fire for last 6
I
years.
don't know.
So
Hanging
therefore,
fire, why?
many may have retired by now. At that time,
What do
in
you have to
2000,
say? What do you have to say? There is another judgment after Rafiq Masi. We are not going to suggest to you grounds. Where is that judgment? Show us.
my lord, I have not got that. I thought that at least the legal issue would get settled, and it's my mistake. I should have, but what I was. So, my lord, the fact is,
Unless that's the only ground. We have made it very clear that we affirm that OA of 2000 was, I mean, though the tribunal quashed it and High Court upheld it, but it was not the intent was not to quash it, but to make it inapplicable to Koshal.
that's right.
Otherwise, had it been quashed, it would have been quashed for pan India.
Yes,
So that's one circular
yes.
which clarifies. And thereafter, there are many high courts, including the high court with which you are very fascinated. Again, Delhi High Court,
No,
there
no,
are so
we've
many
given-
judgments there.
We've given some judgment, I think, of Punjab, Haryana and other, Rajasthan also.
All right.
So,
Just no.
and one is of Guwahati, my friend tells me.
But Milord, the
No, no, no.
Nahi.
Just a minute. So therefore, even if we uphold it,
Utpal Sakya
Just
is
a
of
minute.
Guwahati.
MS Luthra,
Yes.
even if we uphold it,
Yes.
that this OM is correct in its reach, and therefore they would not have got the benefit after 12, 24 or 10, 20, 30, because they already had the financial, they will be treated as direct recruits. We uphold that you succeed that way. But so far as the recovery is concerned, we'll say that those who have retired don't recover.
But those,
Unless you say that there is another dividing line, distinguishing line in another judgment of Supreme Court. Patel hai, dekha. Let's
Yes.
we do not go wrong.
I'll just verify that aspect.
Verify that today we are closing the case today.
My lord, but what I'm saying with regard to class 3, class 4, I'll give your lordship the,
That list you give,
yes.
apart from class 3 and class. Therefore, we say, please
And
have,
who is it?
just a minute, please have a look at Masih.
Very,
Recovery from employees belonging to class 3 and 4, no, complete no. Then says recovery from retired employees or employees who are due to retire within 1 year. Now, this has been explained that recovery from retired employees has to be read cognate with number 1, class 3 and class 4. Where is that judgment?
my lord, I have several judgments which have relied on class 3, class 4. I've not bought them today for reasons that I was perhaps only concentrating with regard to the legal issue. Now, legal issue, my learned friend is accepting.
No,
Now
he's not accepting. He says that this should not apply. He says that it has been quashed by CAT. The other high courts which use that were unaware of the same way having been quashed.
No.
Milord,
It
in my
one.
indicate
I'll give an
there are
answer.
High courts, Milord, which have
MS Luthra, you would do a better, you would do a
I'll-
good job by giving us the details since you're the employer.
I'll
Amongst the respondents who are class 3 and class 4 and amongst the respondents who have retired.
who have retired.
And if you can give any judgment which runs counter to Rafiq Masih, which I don't think you'll get, tell us and we conclude it.
All right.
and Milord, also the pay scale to which we went.
One minute. And the
Was
OA,
it, Mr. Datta? That is your case.
yes.
That's his case. Now, merely because the first scale is higher does not mean that he comes on a higher scale.
It is higher.
So therefore, you have to clarify. That.
It is higher. That's a accepted aspect.
Where have you responded to their statement that they did not join on a higher scale?
No, they have said
They have said so.
Let's see.
And that's the argument.
My lord,
that's
they
the
are
argument.
saying that before your lordship, reinventing their argument. They have joined.
That
1
is
minute.
Page 99, our affidavit is.
Just see my writ.
Page
I have
read your writ. We have seen page 99 of the affidavit.
Infa affidavit. My writ is.
Page 99, para
Where's my
1,
writ?
your lord.
Is
Page,
this one?
paging
Have you
here,
taken
the
the
writ,
writ from me?
page 99.
Oh, yeah.
No, you read out from somewhere with respect to pharmacists, no?
Oh, that is 146, page 146. And 146 is their
For the
document.
count.
Come to page 146.
One. Yes. Yes.
Your medical superintendent says.
But
that
medical superintendent says incorrectly,
medical
that's why.
Medical superintendent of your
Yes,
ESIC.
that is
No, you need
to
to.
our internal memo. That is why we have talked about 2015.
MS Luthra, you have to respond to his affidavit. No.
My
Or
lord,
would you not?
my lord,
Let it go untraversed.
no.
That's your choice.
No, my lord, it's not a question of being untraversed. If your lordship will see 2012 and 15, which are the relevant circulars, which referred to in the review also, the relevant letters, which are inter-office letters. This is not addressed to him. He can't rely upon it. There are umpteen number of judgments of Supreme Court on this,
What?
that the office memo within the
He's
office.
not relying on it as a document of the state. He says that this is actually the fact situation, that the pharmacist in state got
Yeah.
more than in ESIC.
Mm,
That's a
mm.
fact statement. He is only buttressing it by this.
Lord, we
You
have,
need to respond to this.
Lord, I'll just let me read this.
Do it by tomorrow or day after tomorrow. We will fix a date of delivery of judgment.
My Lord, can I just read this out and then read 15 and 12 for a minute?
This is lunchtime here. My brother has to go and sit in another bench, no? We have argued. If we
My Lord, can I appear online on 27, 28? Oh, this is inter-office. Mm.
Look at this.
1
Now
minute.
we have made our views also almost clear. Now OA, we don't take it as quashed. Principle, all right. That principal judgment you have not given, we will find out from ourselves.
Can I assist on that OA as not quashed, as OA merged into the High Court order? Kunamid is clear. So the OA goes in that sense, that OA of Kushal gets explained by the High Court matter.
You're arguing against you, Ms.
No, what?
Not OA, OM.
OM, okay,
Sorry,
I heard OA.
I'm at fault. OM of 2000.
Hmm.
So that, remains on record. That is the direction which is being followed all over the country. This was wrongly quashed by tribunal and upheld. Upheld not the quashing of the OM, but the principle of reversion or recovery. So you have to say 2, 3 things. Number one, the principle of upgradation, which you will find in Honorable Justice Pankaj Mithal's judgment, followed by another judgment of Patna High Court authored by Justice Aswar Kumar. And there are other judgments which would talk about this in situ promotion upgradation and how it is to be applied effectively across. And 3, you have to give us the details because you are the employer. You need to tell us who all were in class 3 and class 4. Question is, we will not permit you to recover.
From those. My Lord, that can be part of the order that from class 3, class 4.
Or the second, unless you tell us that the clause number 2 in Rafiq Masi has to be read cognate with clause number 1.
With clause 3 and 4. It has to. But I'll give your lordship 2, 3 other judgments because for years I see I've made these submissions in other cases or for other service matters that basically recovery.
He forgets that it is only for the purpose of upgradation. So he ignores what scale he is. Even if he is getting a higher scale or same scale, it doesn't have to get into that. He will only say that this shall apply to persons who were absorbed on a higher pay scale, on a higher pay of the work. OM only says that on a higher scale. And if at all it has been given to somebody who was not entitled to it, if he has retired, we will. You give us the details of the respondents. We will
Yes.
not ask Mr. Datta to do it.
I'll do that.
You are the employer.
Yes, my Lord. I'm only bringing your attention to 2 pages in the compilation which is the letter which he
think-
had.
I think you need to come again or argue online, I mean, virtually. Tomorrow. Let
I
me complete
think-
it.
I think, yes. So, my lord, just,
When do we fix it again?
30th.
You
My
cannot-
lord, I'll try and appear online. Can it be 30th?
30th. Why not?
Because ESIC is slow in giving response. It'll take 2-3
You
days.
just have to say 2-3 things and you have to give a note. Who all have retired, who all are this, and a compilation of the judgment after mercy with respect to recovery. Just
My lord, I'll give before and after so that I can make the point clear that recovery should not
to that
be.
extent, we are agreeable with your submission that OM stands. And the tribunal was not right, which has been taken note of by the bench seeing the review. Correct.
That's right.
We agree. We can't be more explicit than this, but we will stop recovery if you don't give us those details.
No, we will. We will, my lord. That's why I've asked 30th. I'll do it online, but I'll definitely
All right.
give the details.
So we close the argument. We will post it for delivery later. Don't need to come. You just give.
Great.
Lord,
We are-
can we exchange the note? Lord?
Why not?
Of course, I'll give whatever I give. I will, of course. give
We'll
you.
post it for judgment on a particular date. On that day, if you want to argue, we will hear you. We have heard MS Geeta Luthra, learned senior advocate for the petitioner, and Mr. S. Datta. S. Datta, no?
Okay.
S. Datta. Learned senior advocate for the respondents. Post this case for judgment on November the 1st. November, I have not met. On 17th of November. तुम्हारे पास है।
Lord, can it then be 24th? I'm actually coming back to India from
You will-
Mexico on 17th. If your lordship needs my assistance, if it isn't required.
When are you
then
coming?
Coming back on 17th. So that's why I was saying 24th. otherwise.
All right, 24th, but then don't charge this court that it has been hanging fire before this court. We don't keep matters on.
But will your lordship also have it before that for this clarification or not?
No.
Or-
It's, we are clear from our side. If you have to give anything, you can.
We'll give.
Post
I'm
judgment. Or we don't say anything. Just arguments to continue, 24th. Don't say post for judge. We have heard so and so. Arguments to continue, 24th.
No.
That, if you have anything to say, you can say that. 24th. Yes, Mr. Snow.
Milord, item number 16 and 17. Understand today there is another combination of division bench. Milord.
It all depends on my brother, whether he concludes that bench and comes, I'll be
Milord,
here.
Can it be fixed on 13th? Milord? Both sides agree.
I appear for the respondent in this case. My-
Item number?
16 and 17.
Okay. 15 is something else.
It's 16 and 17.
No, it's
16
15.
and
15
17.
also is along with 16.
16, 17.
16 and 17.
Daily list. Your list.
It's in the daily list.
16, sir. 15 is different.
16, 17.
All right, 16, 17, when do you want it?
13th. Milord.
13th of
November. Milord.
November, ma'am.
Not a very long matter. Short matter.
let so and so, at the request of the learned senior advocates appearing for the parties, re-notify on 13th of November
Great.
under the appropriate heading.
So far as item number 12 is concerned, 12 and 13, Lord, Your lordship had directed us to give short notes on the argument that we have given. If your lordship kindly fixes a date for
Which is that item? It's about a different case, compensation.
Yes,
land acquisition compensation. Your lordship directed exchanging short notes, we have submitted to the court.
All right, what do you want now?
Well, if a date can be fixed on.
Naturally, if we don't take it up, a date would be given. And we fix in December में कर देते हैं। जो भी बचेगा।
Lord, may I mention item 7, my lord has disposed that matter off. Lord, may I be permitted to submit my written submission without a short note
When?
for assisting your lordship? So Lord, I am carrying it, if it may be allowed to be.
Please,
I'm so,
please, we welcome it.
I'm so great.
We welcome it anytime. Give it now.
Lordship, I have a small point regard to item number 15, your lordship. I am praying for adjournment in this case, your lordship.
Item number
15, your lordship.
15 as prayed for on behalf of the appellant. You're for the appellant?
Yes, your lordship.
As prayed for on behalf of the appellant, we notify January. Subject, sir.
Item number 11, sir.
Lordship, can it be on,
Under my lord, there was some discrepancy with the certified copy. And as per my lord's last order, my lord had directed a copy to be furnished to both the council. The copy has not been furnished, my lord. I pray a copy may be furnished and matter may be posted next week if possible.
Item number 11.
11.
I have received the copy. So far as the appellant is concerned, my lord, the corrected
The
certified
respondent-
copy. He represents the respondent, my lord. He has not received the corrected,
You
copy,
do one thing.
my lord.
In order to, facilitate the entire process, you
My
have
lord.
it photostated, give it to him.
Yes, yes, that will be all right.
Recover the cost if he is not.
My lord.
This fix for considering the matter on maintainability, my lord. Can it be taken up next week, my lord?
My lord,
Because
I-
the victim is not.
Next week it's difficult.
Next to next.
Next week. Second week of November, man. Like, let this matter come up for consideration on, give a date.
My lord. And
1-3.
In rest of the cases.
lordship, item number
And
15,
so-
can it be on the month of November, your lordship? There is some urgency, your lordship.
And what have you said?
On month of January, your lordship.
We don't have that. It's all full. You can try it in December. Give him a date in December.